Adriana Brava. I'm an attorney and I'm here to help you with some deposition tips. This video is designed for informational purposes only. It is not intended to create an attorney-client relationship, and always consult with your own personal attorney when you are about to have a deposition taken. A deposition is a legal proceeding. The purpose of it is to take testimony, sworn testimony under oath. Oftentimes you're going to be in an informal setting in an office that is a court reporter office or another attorney's office. However, the effect is still the same as if you were in a court of law. You are going to be placed under oath. You're going to be swearing to tell the whole truth and nothing but the truth. And if later on it's found out that you were intentionally misleading the attorney, you can be criminally prosecuted for perjury. So it's very important that you tell the truth. And there will be a court reporter present. That court reporter is going to take down everything you say. And because everything will be written down, you always have to remember to give verbal answers. If you say or the court reporter can't write down, nodding your head yes or no. It's almost like you're talking to a blind person who can't see you. She can only write down what is heard. So he or she will sometimes ask you to raise your voice, or the other attorney may ask you if you are going to be, if you said yes or no. Those things are designed to clarify the record, not to be rude, and so make sure you're saying yes or no. Again, the number one rule is to always tell the truth, because you are stating things under penalty of perjury. The best thing you can do for yourself is keep it question and answer. If you start rambling on, if you start talking about some other things, it's not going to help the deposition go smoothly. Everybody's going to become frustrated because you're not answering the questions. So please listen carefully to what is said. A lot of people become really nervous, and because they're nervous, you might ask them what is their phone number, and they give you their address. So make sure you're listening carefully. That's going to help you a great deal. The person asking you questions is an attorney. They have a job to do. You don't know what the purpose of their question is. So the best thing to do is just listen carefully and only answer in a very short phrase, whatever the answer is. If you could answer with yes, no, I don't remember, I don't recall, those are very short answers. They're going to help you to get right to the point and not go into rambling that you shouldn't do. Your attorney will object if it is an objection that they choose to put on the record. You can pause and listen to your attorney so that you can know if you're going to be expected to answer the question or not. Sometimes they're just stating it for the record, which means that they, at a later time, may ask a judge to rule on the objection, and that will be at a later date. However, your attorney will let you know if you should answer or not. But if you're talking too fast and you don't wait to hear the objection, you may actually start speaking before your attorney wants you to. So allow other people to speak, especially because of the court reporter who's going to be writing down what is said. He or she can only take down one person at a time. If you're talking, giving an answer, and your attorney's trying to object, the court reporter can't write down two people at a time. The record will become unclear, and it's not going to be doing you any favors. So just relax and listen to what's asked. And if your attorney speaks up, wait for them to speak before you begin. Okay? So in a deposition, you're not expected to be a computer. You're not expected to remember every single detail of your life. You will be expected, however, to give your best estimate, give your best recollection of events. So if you're asked about times or places, well, actually just times really, you might not remember the year, you might not remember the date, but the person who's asking you the questions may ask you, well, was it more than 5 years ago? Was it more than 10 years ago? Things like that are designed to at least narrow down a time frame and get your best estimate. They're not trying to harass you or make you guess. It usually is because they are requesting your best testimony. So don't take it personally if they try to, get at least a range. Again, they're not trying to harass you. They are just trying to get your best estimate. However, you are never expected to guess. If you truly cannot recall, you can say, I don't remember. That's perfectly fine. If you would be required to guess, also you can say, well, this would be requiring me to guess. You don't want to guess because when you guess, you're just making things up, and that is not your best truthful testimony because anything that's required to guess, you are going to eventually get bit in the butt for trying to make things up. So don't do it, don't guess. I don't know is a perfectly acceptable response. Okay, now there's a difference between a guess and an estimate. An estimate is, for example, if I ask you the size of a table that you have seen and that you're looking at, you can give me your best estimate of what the table might measure. However, if I ask you the size of the table in my house, and you've never been in my house and you don't know if I even have a table, any response you give is a guess. So don't guess, just give your best estimates. Now, when you are specifically preparing for a workers' compensation deposition, there will be a point where you're asked what body parts are affected or which aches and pains do you still have. That is very important that you recall each and every body part because today, if you were giving your testimony and you say, well, my left arm hurts or my right arm hurts, and then later on, when you get your deposition transcript in the future, you change your testimony and you say not just your left arm and your right arm, but then now you're going to include your legs and maybe your hips and all these other body parts that you didn't mention at your deposition. It's going to really affect your credibility. It's not going to be believable at all what you're saying. So give your best testimony and list all the body parts while you're at the deposition so that later on you don't have to make changes. Now, this is probably, I would say, the number one way people get really messed up and don't consider the consequences. Now, in a deposition, even though it's usually in an informal setting, you will be tempted to talk as if you're talking in a normal conversation. That's not good because, again, remember, this is the question and answer. So if you start talking like the way you would normally speak in a conversation to a friend, you might be tempted to exaggerate the truth a little bit. You might say, like if I get home and I'm really tired, I say, oh my gosh, I'm so tired, I'm going to die. Well, obviously that's an exaggeration, that's not true. And it's just an expression to convey that you are very tired and that maybe you have no energy. But here in a deposition, if you say, for example, I always walk with my cane, always is always. There's no exception. So if by chance, say you really truly only 90% use it, but that 10% of the time that you don't use your cane, you are filmed by maybe a private investigator, well, that's going to come back and bite you because you have, at your deposition, locked yourself into a response saying that you never do something. And later on, it turns out that that wasn't true. So words like I never do something, I always do something are very absolute words that you should try to avoid because I know we use that in everyday language, but because this is a legal proceeding, you do have to be a little bit more precise and careful with the words you choose. So if you seldom do an activity, it's better to say that you avoid doing the activity, or maybe you only do it when you've taken medication or things like that. It's better to explain yourself rather than to quickly just lock yourself into a response, because that is the number one way that people later on get some consequences when they're using absolute terms that they would do in everyday language but are not necessarily the correct words that you want to use in a deposition. So be very careful with how you choose your words. Don't lock yourself into a position that you really can't back up. For example, though, say someone who never has learned to drive, doesn't have a driver's license, and never drives, that's okay. Say, oh, I can never drive. But unless you know that for sure, then I would avoid it, and I would use terminology that is more truthful of what you might do instead of cornering yourself in an exaggerated response. So hopefully these tips will help you give your best deposition. Again, this is not designed to be a full list of tips, but those are the biggest ones, and if you can follow those rules and keep your answers short, I think you'll serve yourself well. And always listen to your attorney so that you will do your best. Thank you.